The other two applicants are John and was George receiving.
Yeah.
And my colleagues have informed me that they're still waiting for the
the applications are deferred as well.
The application is deferred. My Lord, we go to Odong.
No. I thought we agreed to deal with the first 15, is it?
Yes.
So that would be number. We ended at 14. Ajotre was the last. Ajotre.
Let's now have
Ajotre. No. I need to pause here to determine whether there is any objection to first the application in principle and second to the sureties which are the ones who have been presented. So I need to hear from the respondents at this point before we proceed to the next group of applicants. So we have received applications from 11 applicants. Are they 11 or 12? Yeah, they are 11. Now I need to hear from counsel for the respondents whether there is an objection to the applications presented by the 11 applicants. Who is addressing court with regard to the 11 applications? Sorry?
We have not received all the documents for the treaty. We say that the organized for us documents from the 8th applicant up to the 11th applicant. We haven't looked at their documents.
You've only had a look at them.
Because of break, and we got copies.
You got copies?
Yes, we got copies.
For the first set?
For the first set.
Before the break? You've not had copies for the second?
The second appeal we have.
So can you specify which ones are missing? Or which applicants?
The 8th applicant we don't have.
8th?
Yes.
The 8th applicant was Tiku Shaban.
We don't have copies of the document.
Who else?
For the 8th applicant, we have only the national ID. We don't have the copies for the LC letter.
Okay, they will be provided, I suppose. You have them?
Yeah, so if they could organize for us to name them.
So it's only the 8th that you... Who else is there?
And 11th applicant. Yeah.
11th is Ijaga Muhammad.
Yeah.
It's 12? The 11th is Andaman, Anwar Doka. Okay, thank you.
Andaman is the one we don't have.
Andaman. Doka. Doka. So there are only 2 sets of documents. 2 sets. Okay. Will you be able to provide copies?
We did pass them on, but I think the numbers are overwhelming. We can sort them as
Okay. That will be dealt with by the counsel for the applicants. Now, what is your response to the 11 applications?
My Lord, we have allowed file affidavit in objection to bail. However, we will slightly depart from the affidavit and we don't have the objection to the application.
So in principle you don't object?
Yes, ma'am. We don't object.
Then how about in terms of suitability of sureties?
That's what we're coming to, my Lord. For the sureties that we were given in the documentations, my Lord, we have no objection to the sureties as well. Same for those ones that we have not scrutinized the document and we are putting them out to court.
Okay, now in terms of conditions,
Yes, my Lord.
do you have any submissions on conditions?
Yes, my Lord.
Yeah.
My Lord, much as we don't object to the application, given the nature of the offense, and also the situation on the ground, the violence that is on the ground, in different parts of Uganda. My Lord, we pray that you be inclined to grant the applicant's bail. You take into consideration some of the grounds that we will request. And these include, my Lord, for the applicants who have travel documents, specific as a passport. Court may be pleased to make an order that they deposit their passports with court as part of the bail condition.
You think they have flight risk?
Especially for the Honorable Parliament, my Lord.
Okay. Anyone in particular, all of them?
All of them.
Go on.
My Lord, also for the applicant to try and contain the violence that is ongoing, my Lord, we pray that court restricts them from unregulated public possession.
From what?
Public possession that would escalate violence.
Processions.
Yes.
But is that a matter for court or for the police? Because, when we impose conditions, these are conditions the court is in position to supervise. Yeah, but now, if you invite court to impose such a condition, how do we supervise it? It would mean we are directing... Sorry? But there are already laws regarding processions. Maybe reminding them, probably. Okay.
I look for the second applicant, that is Cassiano Wadri. He's the MP elect for one municipality, my Lord, where the violence started from.
Yeah.
My Lord, if court is inclined to grant him bail, we pray that his condition to stay away from Arua, where the violence started from, and
this is a court of law where advocates have the right of audience to represent their clients. You can't hinder their presentations to court. Whether you are pleased by them or not, you only listen. You don't react. So respect the submissions of counsel. Whether they are pleasing to you or not, you don't comment. That is for the decision of court.
At least for limited number of of days. One, to allow police to carry investigations.
You are proposing days. Do you have any number of days in mind?
I have a minimum of 3 months.
3 months.
Days, yeah. And to allow.
And the reason is to allow investigations?
One, allow investigations to go on without any violence interrupting again the ongoing investigation, and also to allow the situation to normalize on the ground, especially in Aroa. It's a matter of law, but for emphasis, the court they emphasize to them for the applicant to respect the subjudice law and not to interfere also with the ongoing investigation. We so pray.
But that applies to all parties.
Yes, I know.
The subjudice.
But the other one was for Castellano. Castellano was reordered. Then this one for.
I mean, it applies to both the applicants and respondents.
That is true.
The sub-judice rule.
Yes. On our part, we undertake to.
You undertake to abide by the rule.
Yes.
You only are skeptical, but the other side will not.
We can hear from them.
They need an order to that effect. Okay. Any other conditions you are proposing?
No, my Lord, but court may be pleased to add any other condition for this free. We so pray. But for the sureties that we are still looking at the document, just a minute at a time.
You will respond to that at an appropriate time. Do you wish to respond to the proposed conditions?
My Lord, may I ask my learned friend Honorable Several to respond to that council statement? My Lord, first with the gratitude to my colleague that she proceeds to the application on the conditions that she proposes. Yes, we are willing to draft conditions to the extent that they will not translate into the bail application. Among those proposed, my Lord, is the deposit of travel documents, particularly for members of Parliament. We have some considerable difficulty proceeding to that, considering that members of Parliament travel sometimes as part of their official routine of doing their work. However, my Lord, in the microscopic event that you consider allowing this condition, I pray that you find pleasure, one, in accepting applicant number one, the Honorable Robert Sentam Chaplain, who is in dire need for medical treatment, which we consider to be a matter of life and death, and a portion of which can only be obtained out of this country. My Lord, we are cognizant of the fact that this honorable court can always be requested for the release of passports for a particular duration. However, my Lord, we invite you to take initial notice of the processes and delays that may be encountered.
Well, I'm also thinking of distance. If you have to travel to Gulu to pick a passport, whenever you have to travel, we don't have an international airport in Gulu, so it means visas are obtained in Kampala. Is that a reasonable condition to attach to an application? That is what I'm thinking about right now.
My Lord, it is an unreasonable condition. Even looking at the distance of and the costs involved in instructing a lawyer to make the application, come and fix it, get a response from the respondent, then come and argue. Because
that condition would be a requirement if there is a case for flight risk. But I've not had any submission on the possibility of any of these applicants skipping jurisdiction. So why would I impose such a condition?
I'm grateful. I cannot put it in better times.
Yeah.
But my Lord, even in the unlikely event that court is inclined, then we would pray that that condition be suspended, because at the time of arrest, those members or those persons with passports were not prepared for this, so they did not travel with their passports. And that confirms again, my Lord, that they are not a flight risk in any way. Because if they were a risk, they would have been traveling with their documents. My Lord, with respect to restricting the unregulated procession, when the term itself is ambiguous, because processions in this country are regulated by law. And I fear the risk of this court making an order which will be abused by the police. My clients, the applicants, confirm to this court that they will continue observing the laws of this country, including those regulating, not prohibiting, but regulating processions. More so for the reason given of escalating violence. My Lord, again, the applicants confirm that they are not prone to violence. They would actually, if there was a counter application, they would be asking for restricting the state in meting out violence unto them. With respect to the second applicant, the Honorable Cassiano Wadri, my Lord, the truth is that he has a duty to represent the constituency and to report to that constituency on a monthly basis by parliamentary regulation is required. Whereas we wanted to leave this to your absolute discretion, my Lord.
Okay, I think we need to be candid here.
Yes, my Lord.
There was a transfer of jurisdiction, and the main reason was promoting public safety and security in the area where the offense is alleged to have been committed. and I considered that to be, based on the material before me, a valid consideration. Now we need to assess, frankly, the environment in which this case arose, and the fact that there is need for probably investigations which have to be done in a calm environment. Now, being an offense of a political character, you understand the passions that surround political activity of any sort. Is it advisable in the interest of justice and a calm environment for investigations to permit further political activity for some time, or should we delay political activity for some time?
Madam, we are agreeable to a delay in him returning to Arua. But for reasons not different from what you're expressing, however different from what my learned friend stated at last. Because her reason is that in Arua, where the violence started, to stay away to allow police investigations. Now, one, I want to state that his presence in Arua is not a hindrance to police investigations and will not escalate violence because he's not a violent man.
Well, I understand.
Even in making the concession, I am only saying for different reasons. I want to be on record that actually he's not a player.
He is not a violent person, but he has no control, direct control over the electorate. You understand it?
I agree, my lord.
You are a politician, and you understand. Yes, but you are in your other life. As a member of parliament, you know.
It's not a matter that we intend to drag too long.
Okay. So I think we need to be reasonable here. They have made concessions. We may strike a balance.
Because to the 3 months, and we shall offer alternative accommodation to the Honorable Cassiano.
Just in the interest of public order and for people's emotions to calm down, then we can handle this.
And on the last one, with respect to the rule of service, it is a matter of law. The applicants undertake to continue observing that, and would only invite the respondent to equally observe this same rule. Thank you, my lord. And with the documents, we have submission. Yes, my lord, in the event that you are satisfied, it's our undertaking that we shall continue supplying these documents to our colleagues. This is for the benefit of us all. Thank you.
Well, I may have to write a ruling, but it appears most of the areas of contention are settled. The application is unopposed, so in principle they would be entitled to bail. The conditions are almost agreed as well. I think I'm persuaded by the submissions of the applicants. I don't see any need to impose a restriction on holding their passports. It's inconvenient and there is no flight risk. So it would be a very cumbersome condition. But I find it is desirable in the interest of the progression of this case that we have calm in that area, an environment of calmness in the area, so that all parties are enabled to prepare their cases well without any interruption. As advocates, you may need to visit that area to make your own investigations, to represent your clients effectively. The state as well might need to carry out further investigations to bolster their case and provide evidence. So I find persuasion in the request by the prosecution that the Honourable Member of Parliament elect restrains himself on the constituency until these investigations for both parties are done in a calm environment, then he can go back to his normal life. I find that to be a middle ground, unless there are serious objections. So for the 12 applicants, their applications for bail is allowed. I'll set further conditions so that they don't have to wait in the courtroom. Each of them is to execute a non-cash bond in the sum of 5 million shillings. Each of the sureties as well is to execute a non-cash bond in the sum of 10 million shillings. They are to report to the Chief Magistrate's Court in Gulu. I think the date I read from the file is beginning 30th, and thereafter, as and when the Chief Magistrate requires them to appear in that court. If the case progresses to the point of committal to this court for trial, then they will be required to appear before the Assistant Registrar of this court at such periods of time as he will direct until their trial. So those are the conditions.
But if we seek clarification on the restriction on the second applicant.
The restriction is for 3 months, after which, should it be automatic? I think it should be automatic. Any reasonable investigation must have been done by then on both sides to prepare your case. So after 3 months, you will be free to visit his constituency and carry out his normal activities there. So the 12 applicants can leave the courtroom so that we deal with the remaining applicants. Oh, just a minute. For the second applicant, in the event that there is a pressing need to visit his constituency within the 3 months, then it will be on authorization of court. You can move court for that special permission. You never know. There could be an occasion that requires him to be there. So that can be reviewed, but by an application, a form application before court within the 3 months.
Jaga Muhammad.